All right. People seem to think it's okay. All right, we'll go with this. Stop me if it's a problem. All right, so when we talk about qualified immunity, we need to start with sovereign immunity. So the idea of sovereignty goes back to the Middle Ages, to the idea of kings and queens and emperors. And the idea back then was that the crown could do no wrong. So anything that happened, anything that the government did or that the state did was acceptable. You could not bring a suit against the crown because the king ruled by divine right, and you had no right to question God. But as we moved away from this idea of sovereignty and monarchism, the protections of immunity started to erode as well. But we still have the vestiges of this system. That's why so criminal acts in the United States are still technically crimes against the state itself, not against the victim of the crime. So that's why criminal cases have names like the state of Texas versus John Doe instead of the victim versus John Doe, because technically the state itself is the victim, the crown is the victim. So we still have those little vestiges of this system, even in our system today. That's also, for instance, why victims of domestic violence, for instance, can be forced to testify against their will, because technically speaking, they're not the victim. The state is the victim. The government is the victim, and they are just a witness to this crime against the state. So that's what the criminal justice system is for. The civil justice system exists to make victims whole. That's why civil cases have the two names. It will be Smith versus Jones. The state is not a party to your average civil case. So if you want to be made whole as a victim of a crime, you can bring a civil suit against the person who wronged you instead of just going through the criminal system, which is not designed to make you whole. It's designed to make the state whole. Another corollary of this comes up when we talk about double jeopardy. So a lot of bad TV and horrible movies have given people the impression that double jeopardy means you can't be tried twice for the same crime. In fact, the Fifth Amendment says that you will not be put twice in jeopardy of life or limb for the same act. But without understanding sovereignty, you can't really understand how double jeopardy works. So double jeopardy means that you cannot be tried twice by the same sovereign for the same act. So we have multiple sovereigns in this country. We have the state government and we have the federal government. So you actually could be tried twice for the same act, once at the state level and once again at the federal level. We actually have a third sovereign. I'm curious if anyone can guess what it is before I get to it, but I'm from Oklahoma. So Oklahoma is formerly Indian country, and actually the Indian tribes on reservations still maintain some level of sovereignty. So you theoretically could be tried 3 times for the same crime. If you committed a crime in Indian country and then moved into state territory and then were tried at the federal level also, you could be tried 3 times for the same crime, and that's still perfectly constitutional. So you can only be tried once by each sovereign that has jurisdiction. So that's the idea of sovereign immunity. We still have these sovereigns in this country, even though we don't have kings and queens anymore. So the idea was the crown can do no wrong. And the idea of sovereignty was a complete bar to lawsuit. You simply could not sue the government. But over the centuries, as monarchs and the nobility and the common people jostled for position and fought wars and had disputes and rearranged these power structures, that idea of absolute immunity started to recede. So I want people to keep that in mind. Keep in mind this idea of government sovereign immunity when we start to talk about qualified immunity. So now let's start to talk about qualified immunity. So after the Civil War, Congress passed, we ratified an amendment to the Constitution. The 14th Amendment to the Constitution in 1868 guaranteed the rights and privileges of people, not just against the federal government, but now against the state governments as well. Prior to 1868, things that, for instance, in the Bill of Rights did not apply to state governments. Those were only restrictions on the federal government. After the secession of the Confederacy and the Civil War, people started to think, well, hey, maybe this maybe the states have too much power under the Constitution. Maybe we need to do something to make sure that the states obey and respect the rights of their citizens as well. This was especially a concern for newly freed black people in the former Confederate states, where there was immense concern that there would be reprisals and repercussions against black people in the South after the Civil War ended, and that turned out to be a valid concern. That's what ended up happening. So, in 1871, Congress passed the Civil Rights Act of 1871. This is also called the Ku Klux Klan Act. And part of that Civil Rights Act is still with us today in the form of what lawyers refer to as 42 Section 1983. And what Section 1983 of the 1871 Civil Rights Act does is allow people, individual citizens, to sue agents of their state governments when those agents act under state law and deny people's constitutional rights. So again, the concern it's called the Ku Klux Klan Act because especially in the South, but all over the country, not just in the former Confederate states, people were being abused by their not just by the Klan, but by Klan members who also occupied political offices or occupied police offices or sheriff's departments. So there was a big concern that the police departments themselves, that the government itself in these southern states would be perpetually violating the rights of the people in those states. And under old conceptions of immunity that we just discussed, there was nothing people could do about it. You couldn't sue the state. You couldn't sue the individual person responsible because they were immune. So this Section 1983 was an effort to get around that. It basically erased the idea of complete immunity for state and local officials who, acting under color of law, violated the constitutional rights of their citizens. So 1983 applies to state officials that you can sue in federal court. There is a corollary from a Supreme Court case called Bivens that creates the exact same kind of cause of action against federal officials too. So now we're not just talking about suing the state officials, we're also talking about suing federal officials. If the FBI violates your rights, if Customs and Border Patrol, Department of Homeland Security, or federal law enforcement organizations are subject to the same standard and try to invoke the same protections. So what the Supreme Court, when it starts to get all of these Section 1983 claims, people start suing the government and claiming violations of their constitutional rights. The Supreme Court has to come up with some framework for analysis, some framework for assessing when you go to court and say, that government agent violated my rights, I want money, and that individual person should pay me for having violated my rights. He should have to make me whole. The court was forced to come up with some analytical framework to adjudicate these claims. So what we have now, the standard that we have now basically has two prongs. One, in order to establish a 1983 claim, you have to show that the government violated a clearly established right and that a reasonable person in the officer's position would have known or should have known that their conduct was unlawful. So that's why we call this qualified immunity. It's not absolute immunity. Prosecutors have absolute immunity. Judges have absolute immunity. The state theoretically has absolute immunity. Qualified immunity means it's partial immunity. There is a certain fact pattern that you can establish that gets rid of the immunity and allows you to sue that person. So again, the key takeaway here is that the standard, the government violated a clearly established constitutional right, and a reasonable person in the officer's position or the government official's position would have known that their conduct was unlawful. So the primary fight when it comes to qualified immunity claims are those two prongs. One, maybe we violated their rights, but it was not a clearly established right, or we didn't violate their rights at all. So that's something the courts are going to look at and the lawyers will fight about, whether your rights were violated in the first place and whether this right was clearly established when it was violated. And two, I had reason to believe, this is the officer talking, I had reason to believe that my conduct was lawful even if it wasn't. And if the official or the police officer meets either of those qualifications, the suit is barred and the person who is suing loses and they don't get their money. They just go home. So this is one of the key defenses that police officers, specifically in the context of police, this is one of the key defenses that police have when they're sued for alleged wrongdoing, is to say, my conduct was reasonable under the circumstances, or it did not violate anybody's clearly established right. So this is a very controversial issue. As I said in the opening, this has become a controversial issue in light of all of the debates we're having around the country about police, about use of force policies, about search and seizure, about the drug war. So advocates for qualified immunity will offer several arguments. They will say, one, it's important that we have clear guidelines, that the police officer on the street has clear guidelines. When he pulls someone over, or when he stops somebody, or when he arrests somebody, we need the police to know what the rule is. What the rule is that's going to get them sued, or what the rule is that will have them protected from suit. Another pro for qualified immunity advocates is that qualified immunity prevents officers from being afraid to do their jobs. The argument goes that police have a very dangerous job. They are dealing with high-stress situations. They have to make snap judgment calls. And we don't want a system that is so litigious and so hostile to police that they're afraid to do their job, because they don't know whether they're going to be sued. They don't know whether they're going to be ruined if they're sued in this lawsuit, and they have to hand over their money to the person they wronged. So there's an interest in preventing police from being afraid to do their jobs. And the last argument that you'll run into often is just the administrative cost. Government interacts with a lot of people on a daily basis, and a lot of people are unhappy with the government, with their police departments. And if every one of these people sees dollar signs and is just looking for reasons to sue, and the courts don't establish any kind of rigid structure or any kind of threshold in order to get these suits through, the litigation costs are going to be enormous, and we have reason to put a cap on that. On the con side, people who are skeptical or outright hostile to the idea of qualified immunity argue that, one, it's an important tool for holding police accountable, not just suing the police department. So here I want to go back. I said we should keep this in mind earlier. If you are wronged by the police, you generally have two options. You can do both things, but there are two different tracks you can take. One is to go after the government agency itself. So that's usually the police department, or in most jurisdictions, it can be the city. So for instance, in the Freddie Gray killing in Baltimore, his family sued the city of Baltimore for negligence, for all of these various civil law torts are what we call them, when somebody wrongs another person and owes compensation. So you can sue the government itself, like the city of Baltimore, and now we're not talking about qualified immunity anymore. Now we're back to this idea of sovereign immunity. Or you can sue the individual responsible. So when we talk about holding police officers accountable, a lot of advocates for police reform say, well, the police officer doesn't care if we sue the city of Baltimore, because that money is not, the money that ends up being paid to the victim is not coming from the police officer himself. It's coming from the city taxpayers. So that this without the ability to hold officers accountable and hold them personally responsible, it's very difficult to get them to change their behavior or to punish them for their behavior. Another argument against qualified immunity is that there are very few other remedies. When your rights are violated by the government, there's not a lot that you can do about it. That's especially true when we talk about minority communities, communities of color, communities that lack the political power to really do anything in terms of any kind of sweeping legislative or policy changes. People in these communities often lack the political power to affect change any other way except through these suits. And the concern there is that if we raise the bar so high to get over what are clearly established rights and this reasonable person standard, that it becomes very difficult for people to sue and have their rights vindicated. So I'm sure there are a lot of questions, because this is a very complicated issue and there are a lot of facets to it. But so yeah, I just want to sum up the problem we have here. So the problem is the government violates people's rights. The police violate people's rights. not always intentionally, often completely in good faith and unintentionally. But people who are pulled over, people who have these interactions with police are subject to illegal searches. They're subject to illegal seizures. People have their First Amendment rights violated. It's a very common problem. And so the question is, well, what can we do about this? What can we do about this that allows people to have their rights vindicated, that allows people to be compensated when they're harmed by the government, but at the same time does not make the government afraid to go out and do its job? So that's really the debate that you guys, I guess, are going to have and that you're going to have to sort out. But so with that said, I think I'm happy to take questions from you guys. And should I just start going down the list here, or? All right, I'm just going to start going down the list, all right? And I'm going to start at the top so you guys who asked early aren't missing out. Let's see. Well, I don't know very much about India, so I can't really comment on that. Oh, and Indian nations. Why are the Indian nations like that? Indian nations. So I may have confused people with that point. So the Indian nations are just another sovereign. So that we have three sovereigns that you may run into in the U.S. One is the federal government, one is the state government, and the other are the Indian tribes. Because the U.S. government has a very strange relationship with the Indian tribes over the centuries, and they have some kind of pseudo sovereignty on their reservations in places like Oklahoma and in the Great Plains and in the West. So on their reservations, the Indian tribes are the sovereign. They are the government. They are the law, the legal authority in those places. So they are recognized as another sovereign, along with the federal government and the state government. So when I say there are three sovereigns, that's what I mean. There's the federal government, there are the state governments, and there are the tribal governments. And each of those count as separate sovereigns for purposes of immunity and purposes of double jeopardy. Now let's see here. You guys are doing a good job of answering my questions before I can even get to them. All right, so Federal Tort Claims Act. That's a good question. So there are Federal Tort Claims Act, and then there are the State Tort Claims Act, and they both have basically the same function. Those are the waiver of immunity of complete absolute immunity by the federal government or by the states. So theoretically, we still have this idea that I mentioned at the beginning, that the federal government can do no wrong. And theoretically, the federal government cannot be sued for violating people's rights. Same thing with your local state government. These tort claims acts function as statutory waivers of that immunity. So what these tort claims act do is they set out a list of behaviors, and they say, if our agents in the course of their employment do this list of things, whether this is negligence or malice or assault and battery, things like that, we are going to allow you to sue us. And a lot of times these things will have caps on how much you can recover or how much the jury can award. But so that's what tort claims acts are. Those are, whether they're federal or state level, those are those sovereigns waiving part of their immunity, generally because of political pressure, because they don't want to deal with a system where the government is absolutely immune from suit. The government starts to lose legitimacy in that system. If people have no recourse at all when the government violates their rights, it creates instability and illegitimacy. So Raheem asked, only officials or entire agencies can be tried. So again, when we talk about qualified immunity, we're talking about civil lawsuits so we're not talking about criminal prosecutions here. So like I said, Section 1983 claims are against individual actors. If you want to go against the agency itself, that's where you go back to these Tort Claims Acts in order to sue the city of Baltimore or the state of Maryland or something of that nature. Does qualified immunity necessarily mean no immunity? No. Qualified immunity, in the qualified immunity conception, the only way that you're not immune is if you violate a clearly established right that a reasonable person in your position would have known was a clearly established right and that you acted unlawfully. So outside of that context, you're still absolutely immune. Let me see. What can citizens do if they do not agree or want to go against the government or the decisions they made? Well, that's very difficult. So this system is set up to give people some mechanism through the courts to sue and collect money through compensation through a tort lawsuit. If you lose or if you don't like the way the judge rules or the jury rules, you lose. And if you really want substantive change at that point, that's where it's time to get laws changed, to get new laws on the books, to make it easier to sue police officers, to make it easier to sue the government, just depending on your particular outlook. So that at that point, you're not looking for judicial solutions anymore. Now you're having to go through the political process. So if a police officer thinks what they did was reasonable, no one has the right to disagree. No, that's not true. So when we talk about the reasonable person standard, the courts like to say that this is the objectively reasonable person. If you guys ever go to law school, you'll be very well acquainted with the hypothetical reasonable person. So this is not what that individual person thought. It's what a hypothetical reasonable person would have thought had they been in the same situation. So critics of qualified immunity and critics of police practices in America will often say that courts are too deferential to police when it comes to assessing what the reasonable police officer would have thought in this scenario. So there is that criticism, but at least theoretically, we're not talking about what that officer thought. We're talking about what a reasonable person would have thought in that situation. So if the officer did something that was just completely incompetent or completely in violation of clearly established law, it's not going to matter that the person says, well, I thought what I was doing was okay. So, for instance, something that's clearly established law would be something like you have a right to burn a flag in a public forum, right? So flag burning is protected speech under the First Amendment. If you're burning a flag and a police officer comes up and says you can't do that, puts you under arrest, roughs you up, something of that nature, and then went to court and tried to say, well, I thought what I was doing was perfectly fine, Judge. That's not going to cut it because that's a clearly established right, and any reasonable police officer with a modicum of competence is going to know that that's a right. So no, it's the hypothetical reasonable person. The law means what the judge says it means. That's very cynical, but I don't think I can disagree with that. I mean that's something that's more of a philosophical question, right? And you guys can ruminate on that yourselves about whether law has an external source, which is what many of our founding fathers believed. They believed in this idea of natural law, and their attempt through the Constitution and the Declaration of Independence was not to create rights. It was not to create the law. It was to acknowledge what the law of nature or nature's God is the language Jefferson uses, to whether they were just acknowledging what God or nature had already created. So how cynical you want to be about what the law actually is, I'll leave that to you. Let's see. I've seen a kid get beat up by jaywalking. Explain this. Well, I can't. In my work at Cato, I do a lot of work on our police misconduct website, and I see cases like this all the time. The problem is jaywalking is against the law. So we're not really talking about qualified immunity now because we're talking about somebody who's in violation of the law, and it's not your right. The Supreme Court has not recognized that you have a fundamental constitutional right to jaywalk. So, but if you want to look at places like Ferguson, Missouri, and the DOJ, the Department of Justice issued a report on the police practices of Ferguson, Missouri, after all of this unrest. But one of the things they found was things like police abuse during things like jaywalking, where there was just unnecessary excessive force used for jaywalking offenses. So I can't explain that for you, but I can say that if you get roughed up for jaywalking and you want to make a claim that says the excessive use of force violated my rights, that's what you have to show. You have a clearly established right not to have excessive force used against you, and a reasonable officer under that same situation would know that that conduct was unlawful. So that's what your lawyer is going to have to fight about with the government and with the judge. What about unestablished rights? So that's a problem. That's one of the big problems with qualified immunity. If the right is not clearly established and the police officer violates it, then by law you will not be able to sue that police officer. The courts should throw that case out. The way that works is the more times it happens and the more court rulings you get that say this is established law, the harder it becomes for the police to then say after the fact this was not established. So where that comes up a lot is with things that we haven't had a lot of Supreme Court rulings on. Things like cell phones, where cell phone cameras, so like filming police and things of that nature, where we don't have a Supreme Court ruling that says you have a right to film police. We do have circuit court rulings from all around America saying that. But so if you're trying to film the police and you say it's my First Amendment right, which it is, and every circuit court has found that it is, and the police rough you up, you sue the police, that's the kind of case where they can say, look, we may have violated his constitutional rights, but it was not a clearly established constitutional right. And until we get enough of those cases, you may just be out of luck there. Let's see. What is the difference between sovereign and qualified immunity? Okay, so again, so sovereign is the immunity enjoyed by the sovereign, by the state itself, by a government agency, by the government of the United States, by the government of Virginia. And historically, sovereign immunity was an absolute bar, meaning you could not sue. You could not sue them for violating your rights, period. But that protected the sovereign. Qualified immunity is a personal protection for the agents of the government. So this is about the individual person, the individual police officer trying to protect himself from suit. You're not suing the government, you're suing Officer Joe because you think Officer Joe violated your rights. So sovereign immunity and qualified immunity, they flow from the same kind of idea that the government generally should be protected from lawsuits. But so that's the difference. Sovereign immunity protects agencies, it protects entire governments. Qualified immunity protects individual police officers. Let's see. What are the alternatives proposed to protect police doing their job, but also protecting the rights of citizens as well? Well, when it comes to alternatives, you're not going to find very many people who say we need to junk the entire idea of qualified immunity and it should just be open season on suing police officers, because there is this acknowledgement that the police have a hard job and that we don't want a system where the police are afraid to be police and do police things because they're afraid of getting sued all the time. So the alternatives, the dispute about qualified immunity tends to be on whether the standards are too harsh. For instance, whether the constitutional right needs to be clearly established or whether it can just be a constitutional right. So that scenario I gave you previously where we talked about filming the police, for instance. A lot of qualified immunity critics will say, well, look, if the Supreme Court rules that you have a right to film police, then that cop violated your rights and he should be punished for it, and that can set an example then for the rest of the police officers to know that they can't engage in this behavior. The pushback the other way, like I said, is, well, if the police didn't know, if the police had any reason at all to question whether this is a constitutional right, or the court hasn't declared it a constitutional right yet, then is it really fair to hold us responsible? So I think that's the big fight is about the standards themselves, is about what it means to be a reasonable person, and whether we should have to clearly establish the right before we can vindicate it. It's not so much the idea of just throwing out the concept of qualified immunity. At least politically speaking, I think that's just kind of dead in the water. Let's see. Could a cap be used by a government agent to commit serious crimes but not be forced to pay the necessary recompense required by normal law? Well, so if a police officer is committing serious crimes, then the way our system typically functions there is that officer is then brought up through the criminal system. Not, as I said, when we're talking about qualified immunity, we're talking about civil cases against police officers. But if the police officer is committing actual crimes, murder, rape, kidnapping, assault and battery, things of that nature, then we also have the criminal justice system to hold people accountable there. So we're talking about, when we talk about 1983 and we talk about qualified immunity, we're talking about ways of making the victim of the misconduct whole. We're not really talking about ways to get after police who commit serious crimes. That's what the criminal justice system is for. Do I agree that police officers should be better educated about civil rights, and should they have better connections with communities? That's from Melanie. Absolutely, I agree. I mean, police do receive training on civil rights, on constitutional rights, but the thing is, we have 18,000 different law enforcement agencies in this country. And that's everything from the NYPD to podunk little sheriff's departments out where I grew up. So the level of training and the level of understanding it varies widely by jurisdiction, and it creates problems. But I absolutely think police should be trained and educated and held responsible for protecting our constitutional rights. I think that is the first function of government. If the government, and this you can go back to the Declaration of Independence, that the government exists to secure these rights. And if the government is not securing these rights, then it's failing at its most fundamental function. As far as having better connections with communities, I think it's become very obvious over the past several years that the police have lost legitimacy in many communities around the country, especially communities of color. And again, through these DOJ reports, we're seeing that a lot of this is based on predatory police practices. Things like stop and frisk, things like civil asset forfeiture, just unnecessary escalations of situations. If you're familiar with the Sandra Bland tragedy, if you're not familiar, you should go watch it on YouTube and just see how what begins as an ordinary traffic stop escalates into physical violence for no reason. So absolutely, I think community police relations are in tatters right now, and I think it's incumbent on the government to fix this, because I think the government created this problem in the first place. Let's see. Joseph, doesn't the situation of qualified immunity also set inconsistent standards, since the reasonable officer rule transfers to multiple people with their own beliefs and individual standards? So the idea behind it is to set a consistent standard, right? Is to have this idea that there is this one reasonable officer in all of our minds, and that what that officer thinks is what the reasonable officer would think. And if you deviate from what that is, then you can be punished. So it's actually an effort to bring all of those disparate beliefs into harmony with each other. Now, the problem is you have thousands of judges around the country, and all of these different judges may have it in their own heads what the reasonable officer should do in a given situation. So the problem we have here, though, is it's very difficult to think of how we get around this problem, right? Except the argument would be that we should get away from the reasonable person standard at all. We should just ask ourselves, did the police officer violate the constitutional rights of the person? And if so, then they're liable for the harm that they caused, and just do away with the reasonable person standard completely. I think that's really the only way to get around this problem of having different interpretations and having to fight about what the hypothetical reasonable person thinks. Again, if you go to law school, you'll have a lot of fun conversations about this reasonable person. You'll grow to hate this person. Let's see. Are school resource officers covered under qualified immunity even though they're not necessarily a state actor. In most circumstances that I'm familiar with, school resource officers absolutely are state actors, whether because they're actually uniformed police officers, in which case they're state actors, or they are under contract with the school. And if it's a public school, that then makes them state actors so your school teachers are state actors, your principal is a state actor, assuming you go to public schools. So the problem with school children is not so much the state actor problem. The problem with school children is that, according to the Supreme Court, children in public schools have diminished rights relative to a person in a public forum walking down the sidewalk. So there's a famous school case called Tinker v. Des Moines that is about students during the Vietnam War protesting the war by wearing black armbands. And the Supreme Court ruled in that case that your rights do not end at the schoolhouse gate. So there's this great lofty language about how students are still entitled to First Amendment rights. You still have constitutional rights against the government, even if it's your school. But since that ruling, the Supreme Court has done much to chip away at the rights that students enjoy. So the basic standard that you have now is any behavior you're engaging in that disrupts the learning environment, you don't have a right to disrupt the learning environment. So the issue when it comes to holding school officials and police officers in schools accountable is that they have a much lower standard to say that they were not violating your rights, because basically you only have a right to do things that do not disrupt the learning environment. I personally, I favor more robust protections for the rights of students, especially the free speech and association rights of students. So but that's where you need to focus if you're concerned about student rights, is on this idea that students themselves, because they're under the stewardship of the school, they don't have the same rights they would have, walking on the sidewalk going home. Does inherent bias play any role in qualified immunity? Yes. I mean, of course it does. Inherent bias is a problem all across our system, and it's especially prevalent in the justice system, or at least it's especially obvious and observable in the justice system, because the justice system is where the government and the individual really come into contact, and where their interests really clash most severely and most violently. So yes, judges, so the way inherent bias might work in qualified immunity is, for instance, the shooting in Oklahoma, in Tulsa, Oklahoma, a few weeks ago. The man's name was Terrence Crutcher, and he was outside his car. A police officer pulled up. He was behaving strangely. He didn't obey the commands of the police officer, and she shot him. She shot and killed him. There's footage from a police helicopter in the area, and you hear one of the officers in the helicopter say, "Oh, he looks like a bad dude." And at that point, that police officer didn't know anything about that man except that he was a large black man. That's all the police officer had to go on to make that declaration. So when we start again, going back to this reasonable person, it's impossible then, when a judge, for instance, is trying to decide what the reasonable person would believe under the circumstances, if the judge thinks it's reasonable to form those kinds of conclusions about somebody based on their race or their size, or their gender, then yeah, you're gonna have this bias problem, and you can't really get away from it as long as we have this reasonable person standard. Let's see, special request. What relevant cases that we hear about in the news, such as the case against Darren Wilson, were cases where qualified immunity could have applied or did apply? Second, what are some alternative options for citizens besides qualified immunity that could be used to constrain immoral police conduct? So again, when it comes to something like the Darren Wilson case, yeah, so you're in those cases, you're going to have a criminal case, which didn't go anywhere because they decided that the shooting was justified. And then on the other side, you will have the civil case, or the 1983 case, to say his treatment of Michael Brown violated Michael Brown's constitutional rights. In that particular case, as far as I know, you would have Darren Wilson, because he has the DOJ that came in and said, look, this was a justified shooting, he would probably be protected by qualified immunity, because his argument would be, I didn't violate Michael Brown's rights, and no reasonable person in my circumstance would think that I was acting unlawfully because I was defending myself, And here's what the Department of Justice said that agrees with me. So in that case, yeah, I think qualified immunity would apply and protect Darren Wilson from a lawsuit. On the other hand, as I said before, the DOJ's investigation of the entire police department found a lot of patterns and practices of constitutional misconduct that probably would justify civil rights lawsuits against the department itself or against the city of Ferguson, Missouri. But no, I think Darren Wilson himself would be protected by qualified immunity. What are some alternative options for citizens that could be used to constrain immoral police conduct? Well, that's a very difficult question because of this immunity setup that we have. So, for the most severe instances of police misconduct, that's where we have the criminal justice system, where hopefully you have prosecutors or grand juries that are willing to bring criminal charges and willing to hold individual abusive officers, accountable and responsible and put them in prison if need be. But as far as holding them accountable for just violations of your rights, things like stop and frisk, that's very difficult. The unfortunate answer to the question is that this has to come through the political branches. That's talking to your congressmen, that's talking to your state and local legislators, and coming up with statute. There's nothing that prohibits. So it's important to remember that qualified immunity is a doctrine created by the court system. It's not in the Constitution. The U.S. Constitution doesn't say that police enjoy qualified immunity. The Supreme Court just said that. So you could pass a law that says there's no such thing as qualified immunity, or a law that says we're going to get rid of the reasonable person prong of qualified immunity, or any violation of constitutional rights, the individual responsible shall pay whatever, $100,000, $10,000. So you have a lot of room. Legislators have a lot of room to do really whatever they want to hold police accountable. It's just very difficult. Politically speaking, it's very difficult to push on this and to push for reforms that make police more vulnerable to lawsuits. Police enjoy it's a very powerful lobby in this country, police unions and policemen, and for a lot of Americans, they have an inherent respect and admiration for police, and it's very difficult to go to those people and say, look, we have a problem and we need laws that make it easier to sue police. So it's really a political solution at that point, and that's where you just, if you're really passionate about it, you just need to start banging on legislators' doors and telling them to change things. So, is the justice system inherently corrupt and just stick to simply obeying the laws? Can't we make laws for situations that some would consider previous acknowledgement of these situations, like searching a house under urgency but without a warrant? Yes, the Constitution establishes a floor that the government cannot go beneath as far as protecting your rights. So things like the warrant requirement. If the Supreme Court, for whatever reason, decides that the police no longer need a warrant to search your house, which is the search of your own home, your own residence, is like the prototype Fourth Amendment protection case. But if we imagine a world where the Supreme Court says it doesn't matter, they don't need a warrant to go in your house, we're allowed to pass laws. The legislature is allowed to pass laws that says, wait a minute, the court got this wrong. We are imposing a warrant requirement on the searching of homes. So the government is free to hold itself to a higher standard than the Supreme Court does or than the Constitution does. It just can't hold itself to a lower standard. Okay, and as for the system being inherently corrupt, well, as somebody who works on criminal justice and policing issues every day, I can say that you do start to feel that way sometimes, that the fight is just too hard and that there's just too many problems that need solving. But what good is that outlook, really? It's not. I don't think it's a productive way of seeing the world, because it's hard to change things if you just throw it all off as a lost cause, right? So there is corruption, there is inherent bias, but I think there are enough good people in government, there are enough good people working on these issues and passionate about these issues that don't get caught up in how corrupt things are. Get caught up in how to fix things. Let's see. As far as sovereign immunity goes, is the city local level included when you say the three different parts of it? Could schools be included, since they're could be certain punishments from within the public school system. So that's a great question. Generally speaking, no. City and local governments are considered part of the state. So it's state is the lowest level there. So you couldn't be punished once by the city and then again by the county and then again by the state. That would fall under double jeopardy as all under the state's sovereignty. But the school example you bring up is actually a really interesting question that I'm not sure I know the answer to. Certainly, for if you do something in school that also that violates school rules and also constitutes a crime in the state, you can be punished for both of those things. You can be punished by the school, suspended, expelled, what have you, and then tried in criminal court for the crime you committed. So at least in that school example, I think you're right. I think you could be tried by both, and that's not double jeopardy because the school's punishment against you is not considered the same as like criminal punishment. It doesn't count as jeopardy. Mr. Bates, you can feel free to call me Adam if you like. Is there any specific article or segment of the Constitution that provides government immunity to civil suits? Sure. There are some amendments to the Constitution. I can't run them off the top of my head. I think, I don't know. I think the 7th Amendment, maybe? I don't know. Off the top of my head, there are provisions of the Constitution that forbid, for instance, people from one state suing the government of another state, things like that. But the idea of immunity generally, it predates the Constitution. It's one of these ideas that is just taken for granted by the early Supreme Court and I think by the Constitution that of course the government enjoys immunity. It's just one of these things floating out there that there would have been no question at the time that immunity existed. So there wasn't even a reason to bother writing it down. Could you clarify how qualified immunity is used? Is it something that police officers use as a defense within a trial? Or is it a doctrine that prevents any trial from taking place? That's a great question. I didn't get into that too much because I didn't want to go too far into the lawyer weeds. But so the idea of qualified immunity is not just to prevent judgments against police officers. So not just to prevent bad outcomes, but to prevent suits themselves. So the way it's actually used is that's usually one of the first things the police officer is going to raise is say this suit is barred by qualified immunity. He cannot sue me. So it happens very early in the process, and the idea is not just to protect police officers from having a bad outcome, but to protect them from being sued at all in the first place. So it's one of the first things that happens in these kinds of cases. What happens in cases when it isn't clear whether a reasonable officer would have done what the accused officer did? Well, if it's not clear, if the judge can't make that determination, then it should go to trial. Then that should be an issue at trial to argue what the reasonable person would have thought at the time, and then that's up to the trier of fact, whether that's a jury or a judge. If the case of the plaintiff should be taken in the light most favorable to the plaintiff. So if you can make an argument or put that doubt in the mind, or they don't know what the reasonable person would have done under that scenario, then there should be more evidence presented and the case should keep going. And apparently that was the last question. So yeah, I hope this has been somewhat informative for you guys. And yeah, thanks. You guys have been great, and those were great questions. I don't know if they can hear me, but it's been years for the beard.
Hi everyone, we're just going to ask you to take a couple of minutes to fill out the survey that I'll switch to in this next page. And under the survey, you'll see a link to some other great resources we offer at the Bill of Rights Institute. I hope you'll join me in thanking Mr. Bates for a great presentation. So I'm going to switch to that now. Thank you all so much for participating.